Добрый день, уважаемые друзья. Мы открываем работу нашего круглого стола по личному праву. На правах
Let's start working. It's right in RAM topic. I am Vice President of the Chamber of Commerce and Industries of Russian Federation. I'll introduce the speakers of our roundtable dedicated to right in RAM. Anton Ivanov, he is on his way. He is the presiding judge of the Higher Arbitrage Court of Russian Federation. Roman Bezenko, head of the Department of Private Law of the Higher Arbitrage Court of Russian Federation, and Mr. Chibarov, we expect Mr. Kurakin as well. He is the chairman of the Committee on Municipal Property Management. All those are members of the task force preparing the right in RAM. I would like to introduce you to this division or department. Why did it evolve with the name which is in it right now? I'm here to say that I have been engaged in this task force, so the working group as a specialist as regards the opinion of the Chamber of Commerce and Industries of the Russian Federation. On the whole, we support this draft law. Entrepreneurs turned to us for different issues and implications, and we will present the amendments to the second reading. But on the whole, we support this law, and also we support this division and right in RAM. Why right in RAM? Or property law. Why is that? Because according to this right in RAM division, it's a new edition, because it's called the law of property and other rights in RAM. As to the right in RAM per se, when you look at the volume of that, you'll see that it's a new edition. In many ways, it's about a new division, and as the ideological basis for this, I would refer to the article by Anton Ivanov, which in 2008 was published in the Herald of the Civil Law. Before that, he had a presentation dedicated to the rights in RAM, and after that we decided to identify in a more clear way our ideas about rights in RAM. We thought that was the platform for joint endeavors. This working group or task force incorporated the specialists of the Higher Arbitrage Court, judges mostly, other specialists. As to mere theoreticians, there were none, because it's not a far-fetched theoretical thing. It was hands-on experience based on judicial practices, and out of those parts of the presidential decree dedicated to the development of civil code in 2008, concept and civil code, same goals and objectives were identified for us. I would like to underscore as the basic ones: streamlining the legislation and accounting for judicial practices in that, and stability and soundness of the legislation, and uniformity with the legislations of other countries as well. As the result, there was the division 2 with 4 subdivisions, and the title was changed by no means accidental, because there are lots of different limiting rights in RAM. Now this division is called right of property, law of property and other rights in RAM. No one is called the Code of Rights in RAM, because we have an increased number of rights in RAM. 4 subdivisions are part of Division 2. First, ownership. Secondly, general positions about rights in RAM, ownership right, and limited rights in RAM. Let's start from the ownership. This is a new institution altogether. I'm here to state from the start that we didn't have any bones to break about that. As what is the ownership? There are lots of theoretical implications, whether it's a fact or something. It's a fact, and it was rather the question as to where to include this division, because it's not a subjective law, it's a fact, mindful of the tradition, mindful of where exactly this division is in Western legislations, Napoleonic Code. So we decided that would be the subdivision of the right in RAM, but it's not a subjective law, it's a fact. Ownership, and the draft law is saying about that. Ownership could ensue from subjective right, which contains the powers of ownership. You're aware of that, but this ownership ensues when we speak about the fact not due to this legal power, but due to the evolvement of ownership as the factual supremacy of person over the thing. That's why there are things, there are individually identified things, or the things identified by generic indicators, but they are individualized. And the difference from right and rem, they say that ownership could be part of real property if the boundaries could be identified. This division of ownership, owning a thing, will be most sophisticated and most complex because the institution is very sophisticated and complex. Secondly, it's a new institution altogether, although we elaborated some approaches before. And thirdly, there are other things evolving and questions raised. Why, for example, did we pursue the avenue of presumption of ownership for the owner, but rather followed the way of protecting the follower, the owner, because it's a traditional way to do things elsewhere in the world. It has been gearing towards having the title, the turnover of those things which do not have a title, or it could be limited right in rem, but at least there will be custom of trade of those things in order to counteract those who would like to violate that, like illegitimate possession of a chattel or a land. And oftentimes when the property is to be divided during the divorce, the spouses try to do it illegitimately, sometimes if it's entirely tenancy by entirety. It's a dispute about the fact of ownership. Each subject should prove that he has been owning this thing year prior to the dispute. The other one has to prove that this thing belongs to him. Otherwise, this thing should be transferred to the third party, and the party which insists that this thing belongs to him, in fact, on the right. So that would be a dispute about the ownership. That's about the ownership. And now about the general provisions about rights in rem. As you know, in the theory, repeatedly it was mentioned that, for example, in law of property, we have articles dedicated to real things and rights in rem, but Part 2 Act in Civil Code didn't have the general provisions on rights in rem. And in Anton Ivanov's article and presentation, I found those words. Let's try and introduce general provisions about rights in rem and real things to be aware of the universal norms to be applied for each one of those rights in rem, because that's what right in rem division is all about. There were lots of disputes and controversies, not about introducing those generic provisions, but based on the indicators and determining characteristics which are reflected and embedded into the norms about general provisions of the rights in rem and real things. You should check out those determining characteristics and indicators. They are expanded versus the previous article of the Civil Code because it gives only two main deterministic characteristics. It's absolute protection as well, and Yuri Kirillovich starts contemplating as to whether this indicator or characteristic is there or not. If it is present, that wide new range should be accepted as rights in rem, including release. Now the characteristics of the rights in rem are identified by law, and there is perpetual part of it in right in rem. State registration of perpetual rights to real estate was reflected there. What was not reflected were two characteristics. First of all, the indicator of the supremacy and seniority of rights in van. When it's a claim, it's in favor of the seniority, senior rights in rem. And this could not be even an indicator, but in German law, it's the possibility in right in RAM for the owner to have his own thing. That is the institution accepted by the German law. We thought it was a bit far-fetched and abstracted. It could be misleading for us. That is why we dwelled upon those indicators and characteristics. Out of the novellas, I could underscore that it's a very important part of the rights in RAM. The principle of numerus clausus, which means that it's only civil code which gives definition to those 10 rights in RAM. That is the range of rights in RAM which are around here. We're not going to think about new rights in RAM in the new law. That's a common indicator and characteristics, and imperatively the content of those rights in RAM is confirmed by the law. We preserve this indicator, but we kept in mind that a wide number of different rights in RAM evolves from a contract. The right to development evolves from the right in RAM, and also easement. It's based on the contract or agreement. So there are general provisions about rights in RAM which say that such contract regulation in cases envisaged by law is accepted, and provided the parties deem it necessary to sign such a contract, they will have to reflect the essential material parts of the contract and file them at the Uniform Register of Property Rights. Secondly, if they think something else should be supplemented in their contract, in the same contract, they should agree about that. And if they think that it's necessary for third parties by the same token to take those rules into account, they are obliged to file and register those provisions, because there are lots of disputes dedicated to that, as whether contract regulation and classically imperative regulations be included into rights in RAM. So we follow that avenue. There are some material changes in protection of rights in RAM. Your own practitioners, you're aware of those claims, and based on the provision of the Plenum of the Higher Arbitration Court of 2010, now in the draft law there are 4 real right in RAM legal exits: classical, replevin, negatory, and the claim about the recognition of the right, and the claim about exclusion of the property out of the register. The academics who taught me are here as well. Right in RAM, protection of code of obligation is excluded by this draft law. Of course, researchers could show how it all happened in the beginning, but of course, the right in RAM defendants and protection should exist in the division of rights in RAM. That's part of the draft law. Another thing, negatory claims. You're accustomed to, due to the Article 208 of Civil Code, there is no statute of limitations for such time of claim. Now, statute of limitation is introduced for negatory claim as well. And also, the statute of limitation introduces several requirements about the developments done on the own discretion of the person. But on all those cases, the statute of limitations is not applied. Mr. Ivanov suggested this idea. We supported that. Still, good faith rights holder concept is here as well. The provision and the determination of the Constitutional Court and the determination of the Higher Arbitration Court of 2008 about rights in RAM speaks about that, about good faith rights holders. And the latest text says that if the good faith or bona fide right holder buys this property from the person whose title of ownership is not officially registered, this bona fide buyer is not seen as the bona fide. And also, the complaint, the claim about the recognition of right in RAM should be promulgated in the same mass media which publish the information about resolution, about bankruptcy. It should be covered by mass media. Maybe also because such a claim envisages not just a specific plaintiff, a specific respondent, but when a respondent is not known, when plaintiff thinks that it's necessary for him to submit this claim, he'll do that. That's about rights in RAM. Law of property, lots of novellas here as well. Title and ownership is covered here. Even the names of those divisions, subdivisions, paragraphs and subparagraphs and articles which are included into this subdivision of the right of ownership. There are different grounds, first of all, about involvement of the title through chattel and real estate. They are united, but there are different grounds as well, and they should be regulated. That's what the draft law says. And the titles for new divisions and paragraphs and subparagraphs would not be no together for you, depending on your practice, but it's no for civil code because it's the title for buildings and dwellings and fixtures and premises as to whether premises should not be object of real estate or not. That's a dispute. And resolutions would be based on the practices. All the premises would be divided into main and auxiliary, and there is the shared participation, and also it's not possible to alienate those. And common property division or shared property is very sophisticated too, like farms are not now common, just common property, but it's a shared property now. In practice, oftentimes the issue evolved as whether the owner is entitled to make a contract with a third party to divide his share, to diminish his share, let's say to create out of the entire title the shared ownership. It's not explicit indication of that in the civil code, and the Agency for Registration of Chattel and Real Estate Rights, first they were saying that we do not recognize such contracts. They did want to file them. This is not altogether right, because the practice shows that to turn indivisible property into shared property, it is possible, but there is very stern requirements about it. In the concept of the draft law of 2003 about real property and chattel, we call them dwarf shares. This share subdivided should not be such that it would be possible to use this corresponding part of a thing. Let's say when 1/85th part share of the apartment is sold, and then let's say indefinite number of persons is filed there. This is prohibited when it's dwarf shares. And also spouse's right is identified here. There are lots of disputes about real estate, so that the spouses should be entitled to turn to a registered agency to file their tenancy by the entirety, because there have been lots of disputes about that, but they are entitled to send a petition about tenancy by the entirety. And I guess I will wrap it up here. There are lots of novellas about this law, property and limited rights in RAM. Its fourth subdivision. Its 9 remaining, apart from the right of ownership and the right of title, are described there. All those rights, each one of them has been exercising their own function respectively, starting from the emphasis using the land in order to extract useful properties, this free farm, and also the right to development and companies and have noticed that already, because the right of development substitutes the right of lease in our real situation. In an introductory part to the draft civil code, it maintains that beginning from September the 1st, 2012, if our Lord and Federal Assembly and State Duma will enact this new civil code, beginning from that date, it will not be possible to exercise the building and construction on the municipal lands, on the leasehold rights, unless it's being built and developed for the owner himself. Otherwise, we should exercise either the law of property or the rights to development. This will be a more powerful and in-depth right, mindful of the pre-revolutionary practice and what is in German legislation. It guarantees more rights to investors about this right for development. But as to the tenor and deadlines, tenure of this, it could be discussed. Estonians, after they have become independent country, they have introduced that law, and very long and procrastinated terms for development are not quite lucrative for the developers, and commodities companies were saying, we do the geological perspective, we don't want this perpetual, this 50 years perpetual, which is perpetual, is way too long for us. I'm about to wrap up my presentation, but another, a right to buy somebody else's real estate, which in a way substitutes the right to shared participation in construction, because it's built on the code of obligations, but the right to acquire somebody else's thing or property. This is the principle of free farm. All the fixtures are supposed to be inalienable. Typically, the land and fixtures and dwellings are inalienable, even if they are filed separately. The alienation should be done at one go. It will be a joint alienation for them. Now there will be the discussion of independent mortgage, and I'll give the floor to Mr. Zenga. The mortgage is admitted as the right in real, whereas the collaterals, the way to comply for the collateral, there is the so-called independent mortgage, and Mr. Benzenka has got PhD in that, and he's engaged in collateral. He'll speak about independent mortgage. Roman Sergeyevich, floor is yours.
Indeed, when I've been thinking on how to construe my talk, two ideas came into my mind about the possible subject matters for discussion. One was the concept of the unified object of the realty. It is the entirety of the land and the structure located in it, and the other is independent mortgage. And then it occurred to me that it might be more interesting for the audience to talk about the independence mortgage and the security for it, and that's what I would like to talk. Why the emergence of this chapter related to the independent mortgage makes it right. And for the past 7 or 8 years, we have been observing quite an interesting trend in the law enforcement related to ensuring the obligations, and it became known quite well at the start of the financial crisis, when the indebtors just stopped paying their indebts.
In short, is as well. And I would like to speak about that as well, about the lien in our contract practice and judicial practice and the practice of the agencies for registration of the title of ownership. and transactions with that. Unfortunately, the interpretation and understanding of the current norms of the civil code dedicated to lien are not sufficient for this collateral to be determined as the hard collateral. Unfortunately, we saw that in the overwhelming number of cases, the situations related to normal business rescissions taken on board in the course of extending loans, restructuring loans, into the situation when the mortgages were considered terminated or non-concluded or disrupted. Judicial practices of the higher arbitrage court, first of all, enabled to resolve those very acute issues related to the lien law, but unfortunately the settled down understanding and interpretation of the civil code norms sometimes prevents us to being too flexible enough with those. So there should be some collateral mechanism which will make the value of this thing as sound collateral and pledge. That's when the idea evolved to use the mortgage as such a mechanism of pledging and collateral. When we were discussing specific approaches and resolutions as to how it's possible to use real estate or to use property as a collateral, we've encountered the problem whether there was the accessories or unaccessories of those collateralizations. The doctrine ensued from the fact that any real estate is accessory, but the norms of European law indicates the fact that over 30 to 40 years this has been deliberately weakened, like the German or Swiss provisionary measures or the draft law of unified European legislation about collateral euro mortgage, which was based on the model of a weakened accessority. What is it meant here? It's the weakened links between collateralized debt and the value of the collateral which has been pledged for that loan. Independent mortgage suggested in this project in draft law is based on the idea of limited accessority. There are several important bullet points here or benchmarks here. First of all, accessority means a simplified order of establishment of collateral, of disposal of collateral, and transfer or assignment of the collateral. What do we mean by simplified order of establishment of collateral? Typically, we're accustomed to think that the collateral goes hand in hand with the principal. But the concept of a limited accessority of the collateral means that for the establishment of the encumbrance or the promise to give up part of your property to a lender, this is not quite what is necessary based on the very essence of this structure. Independent mortgage ensues from the fact that the promise to assign part of the value of your property to the lender could be exercised even in absence of the loan. Hence, the independence of this mortgage as a security. What's to do next? Is it possible to retain this full gap between collateral loan, collateralized loan? There is a Krushin, very famous construction for land debt, for when when so that the person in whose favor the encumbrance was identified, he is entitled to a lien. But for that, this commitment is not even needed. It's the accessory mortgage. But we decided not to follow this approach in this new draft law, because this model would be too bizarre for our law and order, and it would be rather difficult for us to do it in practice. In this draft law, there was rather tentative, half a step done forward towards accessority. The draft law contains the rules that in order to sell the collateral and to demand to be given part of the value of the thing which was passed on into collateral, for that the lender is obliged to write it down into the deed of mortgage which establishes the independent mortgage, to write down to this deed mortgage this commitment and this right to lien to sell the encumbered collateral in order to receive back part of the money. We're not dealing here with this abstract, far-fetched, non-accessory collateral. It's rather halfway through. I mean, it's more adequate for us now. Now, as regards to the conveniency of assignment of such independent collateral, in the draft law there are rules that independent mortgage, according to general rule, is not assignable. This is convenient in the situations when, let's say, there is a bank and there is a customer related to this bank by some long-term relationships, and between bank and the customer there are some credit relations when it's revolving loans for credit lines, for committed lines, and for a bank in such a situation it's possible to agree up to 10 million ruble this independent mortgage, mindful of the fact that the lender has been promised a lien in this part, so lenders are entitled to make different contracts, and the debtor, the borrower, could take up different commitments, and the lender knows that there is his right to lien, or maybe even if the debtor reneges on that deal, it will be possible to dispose for the lender to dispose of that collateral. Or in some situations the collateral should be assigned to the third party, so it's possible to assign the independent mortgage to a third party, so that the person, the owner, issues a special mortgage, is ordered mortgage paper which indicates the amount of the encumbrance which is established in the favor of the lender. Due to the fact that this order security is one of the most convenient constructions for assignment of rights, the construction for independent mortgage invested in such a form could be very handy for refinancing those claims, those requirements which are collateralized by such a mortgage. It's crystal clear that independent mortgage is like a heavy artillery when it comes to provisional measures, and one should be very careful about putting together the composition of subjects, of persons who would be entitled to have such mechanisms. When it comes, it's only a commercial organization or company to be the obligor here, not households, not physical individuals. I think it's right altogether, mindful of rather low level of financial literacy among the households. Unfortunately, oftentimes they are not aware of the bearing those contracts will have on them, and we will have to think about limiting the potential circle of obligees. for such an independent mortgage. And now in the draft law on mortgage, they say that as obligee in such a mortgage, there should be banks and credit institutions. This is due to the fact that there could be some tampering and malfeasance and non-bona fide use of such an agreement. They should be offset and covered by the indemnity clause. It's a good remedy when the respondent loses this dispute, but he has got his own property, so which could be negotiable here. So banks are institutions which always have money, and if they lose in this claim, when it comes to provisional remedies and the enforcement, for them it will be possible to deal with that. If this construction of independent mortgage will become into the custom of trade and will be successful, I think that's the way it will be. I think that legislator maybe will change the subject composition. Maybe there could be any commercial institution who might become the obligee of this mortgage collateralized. I would like to underscore another implication or aspect related to independent mortgage. Thing is that this construction is based on the idea of the ability for the parties to construct the content of independent of that mortgage on their own discretion. We discussed that construction with the colleagues, and questions were: is it possible by this independent mortgage to redeem the indebtedness of the third parties? Let's say this independent mortgage is in favor of the banks. Could the banks say that, let's say, this Mr. X is indebted to me, so that would be the collateral used for that, because there could be indebtedness of the third party. But the admission of such an ability is rather dangerous and hazardous, and the legislator does not allow in the establishment of independent mortgage for turning the dementors the claim to a third party. But there are some cases when the obligor agreed that obligee will be entitled to use the promised value also as the recourse for the third parties. If we look at all those norms, we can see that the independent mortgage is quite an interesting construction, which enables us to create quite a reliable collateral on that loan. But when you enter legal relations with very strong obligee, the obligee might insist on such a construction of independent mortgage, which could bring about some breaches or maybe way too strong provisional measures. I would like to call upon you to think about the judicial practices of the recent times, and if you think about this draft law of the first part of the Civil Code, it's also dealing with tag-along and drag-along rights. So the protection could follow this avenue as well. So frankly speaking, the problem of breaching some contract rights when it comes to such provisional remedies and collateral, it could be there. But at least we could see the ways to resolve this problem at the same time. That was all about the independent mortgage.
Okay, thanks a lot, Roman. And I've introduced you in turn as one of the speakers, so the floor is all yours. And we have touched upon the changes effected in the draft code. Of course, we have not covered all the chapter of the rights in REM, and we have covered the independent mortgage as well. So you might add and complement what we have said, and then there will be questions taken from the floor for the chief of the arbitrage court. As far as I'm concerned, the independent mortgage and the collateral for it is actually a very good possibility to avoid the issuance of the mortgage bonds. We were on the brink of issuing them into circulation, and it was just the U.S. crisis at the mortgage market prevented the will of the speculators to generate profit on this asset, and I think we might be able to introduce the reasonable circulation of the collaterals. And take Europe, for example. It was only those banks that suffered that had the bonds, the securities of Freddie Mae and Freddie Mac, and all those who had any bonds survived, and they still feel good at the market, because the collaterals that they have got in accordance with the German law was quite clear what was the realty that was used as a collateral, and what was the price of it. And as far as the bonds are concerned, the price of the realty movables is not seen, and that's the risk that that kind of securities have. I don't think we should develop any drafts of issuing the mortgage securities, and I think that kind of projects will not be in development. Otherwise, we will be facing a lot of challenges, because we will face the similar situation that took place in the US, and it might cause a lot of problems because of the activity of the speculators. But that's not what was actually intended to say. I would like to talk about the criticism that was raised in different mass media publications of the rights in REM, and this is actually one of the last subjects discussed here at the forum, but anyway, the criticism is still high on the agenda, and I would like to subdivide the criticism into three parts. One is failure to accept the theoretical constructions that are used as an underpinning of the respective model. And we cannot do anything about that kind of criticism. The scientists have different opinions and views on the nature of the rights in REM and on the institutions, and these rights have the right to exist as a part of the scientific discourse. But if there are practical outcomes of this theoretizing, like the court practices deriving from it. We are entitled to choose the specific construction, and it might sound strange, but as they say in the army, it is better the things to look ugly but the same, rather than permit to concoct different theories and then to adopt court room practices to it. That's why we have undertaken to express the opinion of the majority while we were adopting the specific theoretical constructions. If somebody is not pleased with that, then that could be the ground for criticism, and they're free to criticize. However, as far as law enforcement is concerned, we should have the things concise, and later on we can have a lot of papers to discuss the theoretical pure theories. Strange as it is, recently the criticism of the rights in REM that was the rejection of the numerous clauses. However, the idea of the limited list is shared by all the authors that are experts on that. However, the latest remarks of the Ministry of Economic Development are related to that. Why should we need so many rights in REM? Let us have just ownership and rent, and let us then describe the rent as a right in REM. That is the latest proposal of the Ministry of Economic Development, and then we wouldn't be able to compile a list, a closed list. But I think the closed list of the rights in REM has got a scientific value. It's an absolute scientific value, and it's an important issue of the legal regulations on what right is the right in REM, and whether the right in REM protection is applied to certain rights or not. As many of you are aware, all the discussions on the nature of the rights in REM ended in nothing, in a naught, and not a single person and no entity did manage to single out the features that either individually or on entirety would define the right of a state, right of REM. And the European theory just boiled down to the closed descriptions. Everything that is described by law as a right in REM is a right in REM. All the other things are not right in REM. And the other things might the theory might go on, but the principal thing with us that we make a full stop to the discussions, and we'd rather not have not the discussions. The discussions could continue, but we shouldn't need the discrepancies of the courtroom practices. Like, you remember how much confusion there was over there associated or related to the right of living in other person's house, and there were many lives that were ruined as related to the right to live in the certain accommodations, and there were rights of certain people that were violated or infringed by the different tenants, and that resulted in the ruling of the Constitution Court. It is the priority of certain issues, and it was related to the different courtroom practices. It is fair to say that the Constitution Court caused it itself when the Article 60 of the code was considered to be wrong. It is denial of the right for accommodation of the convicts. It's a long story, it dates back to a long time ago, but however it still has the implications at present. And in my opinion, and in the opinion of most of the experts in the rights of REM, the closed list of the rights in REM is very valuable. It's a good thing, and we should not abandon it for the clarity of the courtroom practices for the law enforcement. And another issue is whether there are many rights of REM or not, or whether there are few. I think the more the better, because the Civil Code has got a number of the clauses that do not work, that are not applied, but there's no problem with that. Certain clauses are not being used in practice, but there is no harm to anybody because of that. But the situation when there is a necessity for a stable and guaranteed by law right in REM, and this particular requirement is not met, then it would be quite harmful, and that's why the Civil Code of 2000 allowed for the deficiency of the rights in REM that is not being satisfied accordingly, and that's why, and I am convinced about that. And there were 6 or 7 times of continuation of the norm of the land code associated to the land ownership, because there are certain needs of the certain citizens who have rights that cannot be satisfied by either ownerships or rent, and they need some other rights in REM, and it is obvious. Let me give you a simple example, like an old granny living in the central part of Russia, and she might have a land plot and an old house on it. She might have the registration document for the house, but not for the land plot. And to have it registered, she would have to pay the amount of money that costs much more than the cost of the land plot. Why should she then have it registered? There is no economics sense for that. She would be just pleased if she could retain the right of possession and use, and with the right of inheritance, and then she wouldn't need anything else, because the land plot at that particular area will never be the independent economic value, and that kind of need is not met. Or another example for you, just do you know how many times the list of the individuals was changed that can enjoy the right of the lifeland inheritance? It started with the public organization, then it was religious organization, then the list was complemented to include the other stakeholders, and there are more stakeholders that are willing to be included into it. And the logic is quite clear. If the religious organization is non-commercial and it does not have the sources to pay for the rent, and it hasn't got any assets to buy it, then any mechanism of motivation fails to work for non-commercial organizations. That's why willy-nilly they are trying to be included into that list of the owners of the land plot on enjoying the rights of the inherited land life possession. And so the question is whether we indeed should have limited the rights in REM, not to satisfy the needs of the citizens and the entities. The reasons for that were futile. The decision makers were just willing, the owners or those willing to own land plots had to pay money for that. But I think it's a wrong approach to limit the rights in REM just to generate money. I think it is immoral in the least, or it might even be unconstitutional, speaking about the guarantees that the Constitution provides for the owners and the other holders of the rights in REM. And we acted on the fact to describe or to define the list of the needs of the stakeholders, and to establish a right in REM for each of the need. And the only question that was controversial is the right of the issuance of the rights of REM, and we decided to have one reserved right. Since we do not allow any other rights in REM than those included into the list, then there should be a reserved right to describe the changed requirements and needs of the stakeholders. And a decision was made that such a reserved right could exist, and the established practices, experiences of some of the countries, such as Estonia and Georgia, that have instituted that right of the issuance of the right in REM might not be in demand, but there's nothing bad about provisions being made for it. And let it exist as such. And another important thing to bear in mind is the protections of the rights of in REM by obligations, and we made on the instructions of not allowing it, and it is related to the discussion on the proprietary nature of the rent. In my opinion, when certain parties call on a recognition of a certain right to be the right in REM, then there is a trend to ignore the fundamental principles of the right in REM, because the right in REM provides the guarantees for the most fundamental rights, which keep changing, and they cease to exist on the grounds stipulated by the law strictly, and the contractual grounds for the cessation of the rights in REM are not possible because of its nature. And as far as the rent is concerned, and there are other right in REM is concerned, then we have the rights in REM dependent on such a ephemeral notion as the termination or cessation of the contract. How could it possibly to know on the guarantees in such a case when the lease has got 200 pages and the order of termination of the contract is so vague and ambiguous that it is not possible to take everything into account, because the condition of existence of such a right of REM depends on what would be the settlement of the debate on the existence of the contract. It's not possible to technically know about the outcome, and such a problem exists. The rare legally binding documents, like here is a IKEA Moss document, and it's a very large rent lease contract, but the termination of this contract is very complicated. When you are making a lease contract, you yourself can do that. What about the third parties? What about the banks that have the lease contract as a collateral? How could they get the clauses on the termination of the contracts? There is no way for them to do that, and and it contradicts to the eternal principle of the right in REM, with its cessation being part of the objective law. And in case of lease, we cannot be aware when it will be terminated or seized, and on what conditions, and what could be the defendant to put a stop to that. That is something that I am absolutely sure of. That's why we have tried to abandon the rights in obligations, or those rights that could be registered in the register, and it is similar to acknowledging those rights in REM to act eternally. There should be a transitional period with the old rights in RAM to be retained, and this is one of the issues that is pertinent to the oil industry. But I think in the long run, the replacement of the rights in RAM in obligations for the eternal rights will be good for business, and I will try to explain why. Those who are doing the audit of the business know how it's difficult to assess the land plot for the period of 5 years for the development, and its price could vary within any range depending on how the development process is going on, or how you will be doing the work. And it manifested itself in Moscow after the termination of the investment contracts and in the redemption of the losses. You have to understand that the lease contract of a good developer that has a good practice of getting all the approvals and permits, and that can get a green light in all the authorities of in Moscow, is much higher than a small construction company that is being ignored by in all the state bodies, in all the authorities' offices. I'm not going to give you names, and that's why I think the development right, being the right in RAM, can result in the capitalization growth, and can provide additional benefits for them, because even small companies have certain equities and they cannot lose it without grounds for it, and it will result in the capitalization of that particular company, and the rights of business audit will be more transparent in the development area as well. And as far as the oil or the other mineral resources companies will have a possibility to increase their capitalization at the expense of including into the cost of the company of the rights in RAM.
It's a difficult story with the transition period, because it won't be easy to pass through that transition period, and certainly there will be problems of administrative nature. But the long term of enacting all those new regulations will provide for that. Well, the ministry says we don't have any bidding procedures for the construction, and those bidding procedures will bring much more money to the budget than the current lease contracts, which are signed for 3 years, which can be cancelled at any moment, and then you don't have any guarantees whether you will keep the building that you've constructed or not, without visiting lots of offices and lots of officials. I believe that the right of building is much more valuable here, because this right cannot be alienated from you. Whatever you built there does not depend on the value of your right. You've invested actually the price of your land parcel, and the cost of work and contractual building contracts that are also confirmed by your accounting document. And no limitations, because such limitations for agreements of lease are often included right now. So I think that in the long run the business will like the efficiency. Of course, the bureaucrats in state agencies will not like that, because they will have to sell that right at market price in the very beginning, and all the money will go to the budget. It's not like now, when the lease costs a few pennies, and then all the profit is achieved through the sale of properties, and everyone knows which pocket that money goes in. So it will actually mean that all those officials who don't have any business talents will stop getting profits. And I believe that this system of personal rights of rights in REM will provide serious advantages for businesses. As for private citizens, they will have certain rights in REM which will satisfy all their needs. And when you have a small land parcel that you want to operate with the least cost, with the least tax, and when you have an asset that brings you a profit that you want to lease out with certain guarantees, and you want to get certain amounts, what we call the usufruct, and we have a social usufruct in the long run, which also will play a certain part in its sphere. And I believe that citizens will draw a lot of advantages from the transparent real estate transactions, and the right of purchase of somebody else's thing is intended to provide for that. This is a mechanism that doesn't work in Russia currently. So I believe that the criticism that we hear is either due to the misunderstanding of the nature of the right in REM, or partially due to the fact that everyone thinks that all those changes will be enacted tomorrow and lots of papers will have to be reprocessed. But if you read the preamble to the law, it provides for a long grace period and the preservation of the old rights, which is all very important. So if you want, you can stay under this mode. But the idea was to create such advantages of rights that people would like to acquire those rights themselves, rather than impose the happiness of communism on people. That's what I wanted to say about, well, given we don't have a representative of Rosimущество, Russian Property Agency, I would also briefly say that we haven't forgotten the government or state sector. In particular, we tried to exclude from the notion of treasury not only the budget but also all of the state property. We tried to delete that clause, but finally I think it remained there. I can't remember, because there's a lot of inertia. Yes, it's still there, but maybe everyone does not understand the meaning of that clause, but it extends the properties which can be subject to well, we're coming to close to the notion of treasury in the Roman law, and which exists in the practice of many European governments. And by the way, this is a guiding rule for the European Court, because it charges debts from Russia for the debts made by state unitary enterprises, and it doesn't care about the limitation of liability in our municipal unitary enterprises or state enterprises as described by the Russian law. So we'll have to solve this problem somehow, and we cannot be so different from the European practice for a long time. And certainly the fact that we don't retain any other right in REM for the state sector apart from the right of operational management, well, I don't think it will seriously influence the situation, but it will simplify the picture, because it's very difficult to see the difference right now between a right of an autonomous enterprise and a unitary enterprise. Why one is has the right of economic jurisdiction and the other has the right of operational management. I stopped understanding the difference long ago. And that is about everything I wanted to say. Thank you, Anton, for an extended justification of the changes in the right in REM section. I believe that you've used a very good formula during the plenary session. Let us consider, you said, that the representatives of the Ministry of Justice has spoken, and I would make one more. Well, we're trying to get a unified registry of state property for 20 years. I wanted to ask the representative of the property committee when finally they will provide that document to us. Yes, and one thing I wanted to attract your attention to is that among the project clearly delineates a chain of so-called qualified ownership, and that is the property right of a bona fide buyer. And also pay attention to the change in certain mechanisms, and actually it is quite clear what kind of right it is and what is the basis for the arisal of this property right. So the chain between full ownership, between qualified ownership, and the length of ownership is quite clear, and it should not provide any questions. Yuri, I think you have a question. Microphone, please. Please. Now it works. I have a question to you. Well, it is with trepidation that I ask you, because when you talked about the ruined lives, you looked at me very severely, and I thought that I was probably guilty of ruining those lives, in your opinion. It seemed to me, well, you stand for numerous clauses, for a final list, and because of that maybe I misunderstood you. And you, Vadim, yes, I remember writing a review of your dissertation. So do I. By the way, he is really the best expert in the property right. My opponent was Yuri Basin. And Dr. Yuri Tolstoy represented the leading organization, and I still remember his caustic comments. Well, I looked into my archive and I saw my review, handwritten, a multi-page review. I was really horrified by how many recommendations and comments it contained, and I thought that you didn't forget it. But generally the review was very positive. Thanks goodness. Now I have a question to you. On the one hand, you stand for an exhaustive, final list of rights in REM. Tell me please, briefly, the tenancy right under the current law, I mean the right of the tenant, you recognize it. Do you recognize it an contractual right or a right in rem? It's a contractual right. Okay, nevertheless, you believe it a right that you can change that, to transfer it from contractual right to a right in rem. It seemed there was a contradiction in that. Microphones. Very well. Still, I don't quite understand. I could remember the civil code of 1922 much better than the current one. Yes, there's something with Mary. I remember the civil code of 1964, and I nearly don't remember the new one. And I can't remember the new draft law code. There was a clause there, Article 170 of the Civil Code, which was in the article on renting apartment, and it said that the tenant has the rights of court protection against any perpetrator, including the owner. And me and my friends interpreted this as follows. When we speak about these relationships between the owner and the tenant, they are linked by the contractual law. But when a third party violates the tenant's rights, because the owner does not have contractual rights with that third party, so the legal action against this third party could be interpreted as an in rem action. So what is your position about that? And that's my interpretation of the current clause, article of the Civil Code. So what is happening from your standpoint in the defense of that title holder? Well, as far as I understand the logic of our code, this clause will not be applicable to lease or rent agreements, and the tenant will only the owner must just provide for the tenant the possibility to use the thing itself, the thing that belongs to the owner, that is in possession of the owner. But the acts against third parties will not be possible by tenants, in the sense of the draft Civil Code. That was a conscientious choice, plus the owner's protection. Okay. Now the second question. Vadim, to you. I did not quite understand. What concept of ownership you perceived? The Roman one, the difference between ownership and tenancy, or the German one, because you have there a owning servant. Coming back to the... Okay, you lease out a thing. Do I understand you right, that in this case, the owner is only the tenant, and as for the right of possession, it belongs to them both? Is that so? Well, the tenant is the factual owner, and that is a fact. Well, the yes. So he is the owner, but he hasn't the right of ownership. That's right. He hasn't the power of ownership. Well, we did not interpret that. Still, you closely recognize it to a holder. Well, I've answered that question already. We refused from either conception. Quite consciously. We refused from the German concept because we have too many owners. From the standpoint of the current law, when the municipal authority lease out property and then the tenant subleases it. So we will not. They are those rights are subordinated. Do we need to introduce those institute of subordination of rights? It's much too much to have 4 owners of different levels. In the case of tenancy, we did not. We presumed on the difference between ownership and holding, and there's no difference actually. We presumed that it only depends on what the owner and the holder think. We want to provide protection to both them. Well, I mean, the removals company, the shippers, they have the right to be protected by the owners. That was the idea of this regulation. If I'm wrong, please. Well, I want to come to... Well, please remember about my age. I want to come to the bottom of it. Okay, in your case, you only the subleaser is the only owner, whereas the leaser does not have the right of possession. So the right of possession belongs to the lessor or to the landlord. The leaser doesn't have anything, and the fact of possession is concentrated in the subleaser. Well, I got that. Well, you know, I feel a sudden chill when you started, just like when you started talking on ruined lives, and this can ruin the lives of many people who will come across this. And I don't quite understand why you are so concerned with religious organizations. Do you agree to recognize the right of lifetime ownership? Well, this is
perpetual.
So there is a right which holds the other name and which would be included into the civil code. Well, the religious organization is a non-profit organization, but we know what it is in reality. So I understand what you mean. But it's good that you feel concerned and with the life of the confessions and religions. I can see that you are uttering the same slogans as the informal opposition does. Since my birthday, I realized that my name is George. That when I got my passport, but they called me Yuri. Okay, thanks a lot, and it is I would like to tell you that it's 2:15 already, and it's time. It's 2:15, and we are supposed to wrap up at this particular time. So the very last question, and another question from the floor. I am from Rostov-on-Don, and I have two questions. One is about the social lease, because it is non-profit, non-commercial lease related to the perpetual right, and it will be without the rights of protection, and because it's not possible to boil it down to the commercial lease. And another one is the development right. Without deliberating about the rising of this particular right, it is eliminating the construction of the the right for the shared tenancy. Will it affect the concept of the common property of the residential property? We are aware that the main asset is the building itself, and the land plot is a common property, and it is not the house but the land that is subjective to the housing. And so when we talk about the multi-storied buildings, multi-flat buildings, then the development right should be only secondary, and it should be temporary only, because no matter what would be the purpose of the development, whether it would be the sales or the construction in the interest of the future tenants, then the tenants would be the owners, and the rights of the tenants are more formidable for the land plot. So in this case, will the concept of the common ownership will change or not? Let me try to answer. Okay. Ideologically, all the developers were convinced that we should realize the principle of superficies, superseded, and the elimination of all the disbalances that occurred in the past time. But we should act in compliance with the existing environment, and we should be aware of what are the latest changes in the respective regulations. And so we could only hope that at least the new institutions would be formulated on the basis of these principles, with a land plot being a priority and all other things subservient to it. And all the Soviet constructions of these former times of the Soviet Union should be eliminated. But it won't. These legal construction won't be eliminated just like that, and we scrapped the common tenancy by the entirety of the second spouse, and we have been well, that particular right tenancy should be registered, but we realized that it's not possible under the circumstances. That's why we had to abandon it and to reject it. And as far as the question that was asked over here, I don't think anything changes, because the housing code provides for the issues of the land plot as a part of ownership. It will only affect the new land plots that will be acquired by the right of the development. Sorry, the speaker doesn't use the microphone, and the interpreter cannot interpret it. No sound for the interpreter. it's fine, but those fictitious owners will have to pay money first comparable to the market value of the asset. Since they have paid it, that's sufficient. Nothing else should be required from them. And another thing is just the time of existence and the time of ownership. You will pay 95% of the amount of the market value. That should be enough for the ownership. This money will be included into the budget. They will be spent. Then what else can we require? And it will be quite a legal problem if a practice of the withdrawal of the rights of the land plots due to the failure to farm them. And nobody has started the process, but that's an applicable law, and it is related to the right of ownership, and it's not part of the code which is being discussed now, or is it still there? Let me comment on the development. So I have mentioned that we should not be apprehensive of the development right. Just look more attentively at the chapter, and when the right of when the building is constructed on the land plot, then the ownership is handed over to the holder, and then the owner can sell the premises in the building, and that's what is being done. And then the owners of the tenants have the same rights for the land plot as the rights enjoined now. It will be just a share in the construction, in the development right, and some 50 years later we can get back to the definition of these rights, because the construction right will expire. No microphone is used, no interpretation possible. And in the long run, the tenants will exercise the right, and they will be using these apartments, and they will just be standing by for the expiry of this period of time of 50 years. That's what is happening in Germany. We do not deprive them of the right of the ownership. We just replace the rent with the construction right, and we realize only too well that the living houses that are being built based on the right of lease is a profanity, is wrong, because the right of lease is cancelled after the construction is performed. And if the municipality acts all right, no rights of ownership are enjoyed, because with respect to the land plot. And let me just wrap up, because the question is asked over here. Another question is asked, but no microphone is used. I'm keeping a list of your questions, Yuri, but anyway, speaking about the shared construction process, we should not compare the right of acquiring an immovable things to the shared construction right. It does not replace it as such. And the social lease, there was an answer given. We do not provide the right in rem protection, because it is not a right in rem. At least that's what the decision taken, because we have distorted all the system of the housing relationship with those social benefits and social transfers. Sooner or later it will be terminated, and we should introduce the market instruments into this particular area. And the citizens that should enjoy the benefits and the bonuses should have the apartments in the housing owned by the state. That's what is happening in the other countries. It is social apartments accommodated to them if you cannot afford to buy it, and all the other tenants should just act on the market, and otherwise the residential property construction will never be developed at full swing. Take Kazakhstan, for example. The 100% of the tenants pay for their quarters and the utilities, and their housing state and conditions are quite different. If we had effected it long time ago, we would have adapted to it a long time ago, and the situation would have been different. And if the applicable law as it is now, we won't have the rented rent and lease market in the housing property. So you should not put the cart in front of the horses, and the generation that I belong to and the other generations will have to perish first for these things to be effected. Well, Yuri Kirillovich, definitely you are the owner of your residential property, so you will have to live long, and nothing will change in your mode of conduct, and you will have to write nice and fine reviews of the dissertation papers and of the thesis. And at the moment, we pay the same money as in the market-driven economy. The countries, they do not have any benefits or bonuses or social transfers. That's the problem, because the utility sector now abuses the money and wastes it unless we reform it. Another question on the mortgage. The practices are controversial, and the credit to the physical person does a mortgage, and the bank money is used for other purposes. And can a bank then introduce a penalty on the housing property? This is the questions to the general jurisdiction courts, not to us. The Constitution Court reviewed this particular issue, whether the penalty could be imposed on the only property owned, and your question is just aggravated by, or is the residential property mortgaged or not? The speaker doesn't use any microphone, the interpreter doesn't hear it. No, it's not on the draft law, it's a different matter. Okay, I think we have exhausted the issues, and let us thank the speakers. It's the end of the round table discussions, and please read the chapter. There are many novelties over there, and don't feel apprehensive about it. Thank you.